we've got an hour and a half or around 25 minutes now. So I'm going to do my best to make sure that there's stuff in here which is useful for everyone. There are some areas which obviously we don't have enough time to go into a huge amount of detail with. So, in one sense, just to say it now, the YouTube channel that we run has got, I don't know, hundreds of hours basically worth of information on there. And there's some playlists in there as well that you can kind of just navigate to as well. So if you see something like priority needs, we don't have enough time to really go into that in any detail today, but you can go and have a look on the YouTube channel, just search for priority needs, you'll get a bunch of stuff basically. So it's not legal advice. I'm not a lawyer at all, and Will is a lawyer, but he's still not giving legal advice today. We'll give a little bit of an introduction in a moment just to say where we're coming from and kind of what the context is of what we're talking about. But as with all these kind of things, you need to go to the direct source, probably the Homelessness Code of Guidance if you want to quote stuff. The slides themselves will quote the Code of Guidance a little bit. There's some case law in there as well, but obviously don't be relying on the slides in themselves. You want to be checking out what you're doing. In terms of what we're going to spend the afternoon doing, I've tried to extract all the different bits and pieces of homelessness law that's going to be relevant to social workers. And obviously, it's a bit of a kind of you work in various different remits, whether it be adults or children's or safeguarding or emergency duty team or hospital discharge or whatever. I'm hoping there's going to be stuff in the slides that are going to be useful for everyone, but I appreciate some areas might be more relevant than others. And I guess just talk about some common misconceptions about the law. I have a job because councils across the country don't follow the law. Basically, that's kind of what it's all about. And so, yeah, it's really kind of just aimed to bring everyone up to kind of like a base level of understanding and start building on a few areas and kind of highlighting some areas which you may well want to know about. In one sense, I'm amazed that homelessness law is not kind of dealt with in more detail in social work degrees. That might be, maybe it's just in our local area. So I'm in Bedford. University of Bedfordshire does very little at all about homelessness law, which for me just means you're missing out some really kind of easy wins in pretty much every setting, really. So just quick intro. As I say, I'm not a lawyer or anything like that. I've worked in the homelessness sector since 2005 in and around Bedford. I am a former council whistleblower, whistleblew back in 2013, and since then I've set up a couple of organisations to challenge unlawful practices by councils. Along the way, met Will, so we kind of do a bit of link-up work with casework and bits and pieces. And since 2017, I've delivered training to lots and lots of people around the country, just in England, by the way. So if we've got anyone from anywhere other than England, I hate to tell you this, but this isn't going to be directly relevant. Although just to say Wales is pretty similar to English law, it's not identical. Yeah, and basically have spent my time getting people housed by getting the council to apply the law properly, getting people compensation along the way, for various different kind of reasons, various different failures that we've seen. And although I've focused the work on Bedford Borough Council, you know, I've dealt with probably 30 or 40 councils now, all of one of which broke the law within a few minutes of contacting them. So we're talking about stuff here which is very widespread. As a general rule, the closer to London, the harder it is to get the councils to follow the law. But, you know, that's not to say that every council doesn't have its challenges. So that's me. Will, do you want to do a quick intro as to what your background is? It'd be me doing most of the talking today, guys, I'm afraid. Will's just going to chip in at various bits when I'm struggling. So, yeah, Will.
Yeah. Hello, I'm Will. I'm a solicitor, and I have been specialising in housing law and homelessness for a very long time, since the sort of mid-90s now. And I have found that has spread over into issues of adult social services and or Children Act, and as well, and issues of rights of children under the Children Act 1989 and 2004, and support for adults under the Care Act. So that often overlaps with the more sort of traditional homelessness law under Part 7 of the Housing Act 96. So that's me. I'm based in London, and I do spend a lot of time challenging local authority decision making and judicially reviewing or appealing homelessness decisions.
For those who are of that kind of or inclined that way, feel free to use the chat just to introduce yourselves, whereabouts in the country you're from, and you can start putting any questions you might have into the chat now. As a general rule, I'll try and answer questions as soon as I see them, if it kind of ties in with the slides. But obviously, sometimes I'm going to be referring back to things as we go through. But we're going to do
an eye on the chat. So I'm watching the questions if anyone's got any.
Yeah, quality. Thanks, Will. Before we get into any law, I've got a few slides here just to set some context, because it's important to understand this stuff, I'd say. And the first thing I want to say is that although the law across England is the same within the Housing Act 1996, Part 7, as in the homelessness bits, The ways in which local authorities struggle to follow the law are, there's this disparity is really quite something. This is just one of the ways you can demonstrate this. This is the average waiting time for a two-bed property for people owed the main duty. I'm appreciate I'm already using quite a lot of jargon there. And if you look at the key there, I don't know how well you can see it actually, but we range from less than 50 days up to more than 3,000 days. And so there's various local authorities in London that are over that 3,000 day average. Whereas, I mean, the shortest waiting time I'm aware of is Bassett Law, which I did actually check them out because I couldn't believe it when I saw it. But they basically have an average waiting time of 6 days. So the point I'm making here is that we hear the headlines, we hear headlines about Croydon and Nottingham and various other kind of, Birmingham, those kind of councils, and we hear that they're bankrupt and they can't follow the law. The reality is that for most people, most areas, it's not as bad as that. Now, it's not great, don't get me wrong, but basically, I'm hoping that's at least a little bit of an encouragement to understand that if you are doing social work in various ways, there will actually be a number of opportunities for people to be supported to apply to a different area. I'll give you a very quick example of that. Well, it was last year now, actually. So last summer, a lady approached Bedford Borough Council. She was heavily pregnant and fleeing domestic abuse, and Bedford predictably gate kept her initially, but we got that sorted out. We got her into emergency accommodation, interim accommodation. And when I sat down with her, once she had a bit of moment to kind of figure out what she wanted to do, I spoke to her and said, actually, do you know what? The average waiting time in central beds is half that in Bedford Borough. You don't have any reason to be in Bedford other than the fact that you've got a tenuous friend here. Do you not want to just approach central beds instead? So that's what she did, approach central beds, who after a week or so started following the law. They accepted the main duty about 2 months later, and she got housed in social housing earlier, beginning of January this year. So that's just one example of ways in which you can use this kind of data to kind of help people get housed as quickly as possible. But just understand that, just how much this varies and the difference that makes to approaching a council. In London, reality is you need to get someone like Will involved to actually get the council to follow the law. It's not until you threaten judicial review that they're going to really budge and do much use. Whereas in many areas, you can get really good outcomes with relatively little effort. So as I say, I'm hoping that's vaguely kind of encouraging rather than miserable. But it's just important to say, just as I say, just kind of how this does vary. Another thing to say before we get into the law properly is that this is an adversarial process. So basically, when someone makes a homeless application to a local authority, in one sense, although I'm being a bit clumsy here, in one sense, the council's job is to advance the best legitimate argument that there's no duty to house that person. And let's be honest, often it's going to be illegitimate arguments. It's going to be, kind of misconceptions and so on. And then the homeless person is expected to use this very complicated legal process to push back and kind of get a good outcome. Now, that's not realistic for many people, most people, I'd say, because when you're homeless, it's unlikely you've got the latest textbook in your bag to kind of know how to challenge the council. Let me see. So, yeah, with that in mind, the power imbalance here is massive, and that is why we see so much injustice, because many homeless people across the country are routinely gate kept. They're routinely given perverse negative decisions, and unless someone, someone in a better position than someone who's homeless is going to challenge that local housing team, we're going to continue to see that kind of injustice happening. And that is to say that if you're working with someone, it may well be you're the best person, best position to actually challenge the local housing team, and you can leave it to someone else. Unfortunately, there probably isn't anyone else, so you're probably the best person, or the best person in that person's life at that time to get a good outcome. And in my experience, every single homeless application will encounter some resistance somewhere. So yeah, it's often very early on. It might be rejecting the application, it might be rejecting kind of very obvious medical evidence or something like that. But unless you're willing to kind of push a council housing team, you're going to struggle to really get anywhere with it, really. So yeah, that's kind of, as I say, a bit of a context, really. Just to kind of say this as well. So I trained social work teams around the country. I've kind of many hundreds I've thought over the years. This is kind of a rhetorical question rather than one I want an answer from. But I'm always interested by how, when I train social work teams, they seem to be quite fearful of the housing officers, and I don't know why that is. I don't think I'm wrong about that, but it does. I just kind of see this sense of fear when you're talking about challenging housing officers. Just to say that as social workers, you're going to be better qualified, better trained, probably have more years of experience under your belt. You should not be fearful when you're challenging the housing officer about something which is plainly, obviously true, whether it be medical priority or kind of someone's care and support needs or something. So again, that's meant as an encouragement, really, to kind of hope to help people just realise that you can challenge the council and these kind of things. So yeah, right. Let's start actually talking about some law. So big picture laws for a second. This is a case you may have heard of, Imam v Croydon from 2023. It was a Supreme Court judgment, and basically it just, I guess, it sets the scene for how the law should work. Obviously, the law doesn't work, but it can work if you want it to, and if you want it to enough. So in that case, it involved a family who had children with, I think, at least one of the children had a quite significant disability. That meant they needed quite kind of particular type of accommodation to meet that child's needs. And Croydon Council basically said, look, we ain't got any money, we're bankrupt, we haven't got the sort of housing this family needs, and furthermore, we don't have, there are 16 other families ahead of this family on the list. Got all the way to the Supreme Court. Big question: do councils have to follow the law? And this was the answer from the Supreme Court judges. Constraints on resources are not a reason for not complying with the duty imposed by Parliament. The duty owed is immediate, non-deferrable and unqualified. The fact that Croydon may not have resources immediately available to comply with the mandatory order will reflect choices it has made in the past regarding use of its general resources. And if it does not have suitable accommodation immediately available, why should it not be expected simply to call on its general resources, perhaps by borrowing money, to adapt an existing property or to rent or buy a suitable property without delay to add to its stock of immediately available resources and comply with the order in that way? So what it's basically saying is, if a council doesn't have the resources to house people, that's its own fault. It's basically made decisions over decades which has led to that position, and it is not for the homeless person or the homeless family to have to deal with the kind of the fallout from that. And as we saw in this case, if a council says they don't have a suitable property, then the duty means they would have to potentially go and buy a suitable property if that's the only way to do it. So that kind of sets us up really to understand how kind of powerful this law can be if we just believe in it. The order of the slides here is in my mind a logical way to go through this. There are other ways to do this, but this, in my mind, as I say, is going to be the best way to kind of get the message across, really. And so I guess it's not that unsurprising. We're going to start with the legal definition of homelessness, and we're going to use that to then kind of make some points quite early on about a lot of confusion that arises in housing and homeless applications. So Section 175, you don't need to remember that particularly, of the Housing Act 1996, sets out three situations when someone is already homeless, and a fourth, well, and technically fifth situation, although I've combined them here, which would say that someone is threatened with homelessness if they're likely to hit one of these three situations within the next 56 days. The good news is you can then make a homeless application without having to wait until you're actually homeless. Now, again, there's loads of stuff I'm not going to be able to cover in the time here, but if you're working with someone and they're worried they're about to become homeless, there's nothing stopping them making an application today, rather than kind of turning up in the customer service centre with all their suitcases in a couple of months' time. And so if we then look at the three different situations, broad broad situations, the first one is, someone is homeless if they've got nowhere with a legal right to occupy anywhere in the world. So this would cover your obvious situations like rough sleeping or sofa surfing. So again, there's loads I can kind of go off on tangents here, but I'm going to try and keep it concise. Secondly, we've got people who have accommodation with a legal right to occupy, but they can't get into it. Maybe the landlord's changed the locks, they've illegally evicted them. It might be they've got a caravan or barge, but they've got nowhere to legally put it, or they might have accommodation, but they just can't afford to travel to it. So they're homeless as well. That's probably the least interesting of the three, to be honest. But doesn't mean there's not going to be situations where that comes up. And then thirdly, and by far the most interesting, is people are homeless if they don't have accommodation where it would be reasonable to continue to occupy. So this term reasonable to continue to occupy is where things immediately get rather complicated, but potentially very good, because many of the situations I've kind of worked in with social workers involve people who, they might be subject to abuse, they might be subject to medical issues which mean they can't get up and down the stairs, those kind of things. All of those kind of things enter the ballpark of this legal definition of homelessness. So here's there's more than this, but this is kind of maybe the most kind of common six of this category. So we've got domestic abuse, as I say, and other types of abuse like cuckooing, serious harassment from neighbours, that kind of thing. You've got unaffordability, which gets very interesting, although unfortunately the case law on which defines that is not terribly clear at the moment. But in effect, you are homeless if you cannot afford to pay for the essentials of life, like your food, utilities, and phone and kind of internet and TV license, that sort of stuff that people are going to need, and also pay the rent. So again, you are legally homeless now. You don't have to wait to get into rent arrears before you can kind of present to your council as homeless. You've got situations where the nature of the accommodation is impacting on the kind of the occupant's health in some way and well-being. So it could be something like severe damp and mold that's causing breathing issues, for example. So Awab Ishak was probably homeless, and probably made an application to his local council, or his dad did, and the council probably gate kept him. The coroner's report is a bit vague on the details, but that does seem to be the case. You've got people who have a disability, they develop a disability where maybe they can't use the property or they can't enjoy the full property. So let's say they develop a mobility issue, they can't get up and down the stairs, and therefore they can't get to the bathroom or something that's upstairs. Those people may well be homeless. You've got significant overcrowding. Note it's not just any overcrowding, it would have to be kind of, unusual level of overcrowding, let's put it like that, which has an impact on the occupants. And other sorts of severe disrepair, so category one hazards, and as I say, kind of physical issues with the property. So I would imagine many of you will work with people in these kind of situations pretty regularly when you think about it. But the problem is that people don't necessarily recognise it at the time because these are quite obscure bits of the law. And so you're working with someone for quite some time who, they're on the housing register, they're bidding for properties when actually there would be the option of making a homeless application and getting suitable accommodation available much more quickly. So again, I'm just going to give some kind of real kind of quick headlines with this stuff. So with domestic abuse, it's not about the severity of the abuse or the type of abuse. It could be any type of domestic abuse. It's just about whether the abuse is likely to continue. So yeah, as soon as that is the case, that person is legally homeless. They don't need to flee the property to be homeless. It just means that they can approach any council in the country, basically. And essentially, the way it works in reality is that any council they approach is likely to owe them the main housing duty, which is the really good one, or certainly some other type of housing duty, which is going to be helpful. There's some really interesting cases here, which I will mention because of the nature of you guys' remit. There's a case called Lomax v Gosport, which is a 2018 case. Very quickly, I mean, it's a very detailed case, but essentially, Miss Lomax had significant mobility issues. So essentially, she wasn't able to get out and about. She wasn't able to mobilise. She lived in the middle of nowhere in Dorset. Her family all lived 60 miles away in Gosport. And so she approached Gosport Council and effectively said, yes, I've got a home. Yes, I've got a legal right to occupy it. But the fact that I can't see my family, the fact that they can't meet some of my care and support needs, means that my depression has been getting significantly worse, as evidenced by the GP, I think, or maybe even psychiatrist. And yeah, effectively, the isolation of the current accommodation was causing a protected characteristic in the sense of the depression to get significantly worse. It went through the courts, got to the Court of Appeal, and effectively the judge said that, and again, this is really kind of clumsy, but effectively because the accommodation was having a significant impact on a protected characteristic, she was legally homeless now, and therefore she was able to apply to Gosport. It was very, it's good for a number of reasons because the family in Gosport were able to meet many of her care and support needs anyway. But that was the kind of case where you see this idea of, it's not just about not being, with a roof, but it's actually the impact on someone's health. Now that is a high hurdle to cross. Many cases many thresholds within housing law are very low. That is a particularly high one. If you're going to start using this sort of stuff on a regular basis, don't start with this situation, start with easy ones, basically, because it is a skill. And unfortunately, the nature of housing law is that the first case you have, the first battle you have with the council's housing team is going to be the most difficult. Once you kind of win one, everything gets a lot easier. And then another case here is an old case. There are other cases, but I'm just kind of giving some headlines here. It was a case called RV Medina XPD, which was a case involving a mum with a young baby who was living in a beach chalet, which was unheated. Damp and mold developed. The GP said that her baby's breathing was been affected by the damp and mold. Therefore, she was homeless. Therefore, she got rehoused, which is why I kind of mentioned Ivar Bashak, because, as I say, he was likely to be homeless anyway, and he should have been rehoused most probably. So, yeah. Other kind of cases. Now, in fact, this is probably a good moment to show you the local government and social care ombudsman database that I've compiled. I'm sure most of you heard of the local government and social care ombudsman. Obviously covers both housing and adult social care and children's services, actually, for that matter. Everything about the website is amazing except the search function on the website. It's terrible. So what I've effectively done is compiled about 200 plus interesting cases on the LGO website in this table. So again, I'll put this in the chat in a little bit, but it's in a PDF. So it gives you the kind of possibility of searching for particular words. So if we search for the term unsuitable, for example, we get a whole bunch of cases which involve unsuitable accommodation, and you find the case you want to find out about. You then get this number here, which is the case code, take it to the LGO website, stick that into the search, and you'll get the full case study there. There's a little video here as well, just explaining how this works in more detail. But so yeah, just as I say, if you really want to use this law a lot, this is a great resource because it can really help with the gaslighting that goes on when you're dealing with housing officers. Because unfortunately, and just to say, not all housing officers are like this, but many housing officers sadly will just kind of tell you stuff which is specifically false, and the temptation is to give up and think that they know best, when actually really you just need to sort of kind of see how these principles work in practice. So looking at how the LGSCO unpick cases and kind of offer compensation can be a really good way to kind of understand how the law works in more detail. Plus the fact you've got the crossover between these different areas of law. And I don't know of a better resource when it comes to seeing how adult social care children kind of act stuff interact with homelessness law in such detail. So yeah, as I say, let me put it in the chat now before I forget actually, so bear with me a sec.
Mike, can I just plug my case law database as well now? I put that in the task in the chat as well.
Yeah, cool. Thanks, Will. Yeah, so yeah, I mean, let me actually press enter. So there's a huge amount of stuff, but yeah, between so Will runs his website. We've got a little thing going on as well. Basically, what we're trying to do here is get this information out there so people can use it, because you can get some amazing outcomes very easily, or relatively easy, with a relatively little work that can make a big big impact on people. Yeah, so unsuitability can also make someone homeless. But again, there's not enough time to unpick it in any great detail here. There's an example here on the slides which involve a family with care and support needs. They approached the local authority multiple times before the council actually followed the law properly. And so I think in this case, they got about £2,000 compensation, which for the Ombudsman is, reasonable amount, I guess. So that's the definition of homelessness. Now that we've done that, we can start unpicking how the process works, because they couldn't have done a better job at making this incredibly confusing, because you've got two processes happening at the same time, or not happening at the same time all the time, but that will often interact and just can confuse the hell out of everyone. Within the Housing Act 1996, there are two parts that we care about. There's Part 6 and Part 7. And in effect, Part 7 is the process that is used for someone who is legally homeless or might legally be homeless. And Part 6 is the housing application process that is for everyone who is not legally homeless. Because effectively, in certainly most areas, it's getting tighter these days, but in most areas, you can apply for social housing without being homeless. You need to have some kind of housing need generally. But effectively, the way the law works is if you are homeless and you approach a local authority, then you should by default be taking down the homeless application, the Part 7 route, rather than Part 6. And it matters a lot because there is no immediate emergency accommodation duty under Part 6 at all. You could be waiting for 20 years to get housed under Part 6. Whereas under Part 7, there may well be an immediate duty to house you, even in the middle of the night, potentially. So these terms, I mean, this is just examples here. There's actually more terms that make it even more confusing. But effectively, your language matters when it comes to the law. So a housing application is not the same as a homeless application. Housing application would generally mean the Part 6 application route. The homeless application would be the Part 7 route. Remember, it's the housing team's job to recognise the difference. It's actually not your job to know that. Unfortunately, many housing officers won't know the difference either, so they'll leave people who are legally homeless. They might be subject to, severe domestic abuse or something, and they just simply don't get picked up under the right process. So there isn't that immediate response to their situation. Housing need versus homelessness. So effectively, to apply under Part 6, you need to demonstrate some kind of housing need, whereas which essentially won't be as severe as being homeless. You've got terms like priority banding, medical priority. So your local policy, which is locally set under Part 6, to confuse you even more, will have some kind of banding system: 1, 2, 3, gold, silver, bronze, A, B, C, whatever. And so a lot of social workers I work with, they know a little bit about their local policy, but they then get confused between that policy and how the homeless application actually works. There's other differences probably worth flagging out at this point. So I've just mentioned it, actually, I've alluded to it. The Part 6 process is locally set. And essentially, the closer you get to London, the stricter it will get. Whereas the Part 7 process, as in the Part 7 definition of things like local connection, is nationally set. So again, we're going to come back to these in more detail, but just to understand that there are two processes and you might not even realise it. And you won't realise it because on your council's website, it won't tell you this. It would basically have a little tab which says, do you want help with housing? You click yes, and then generally they'll take you down the Part 6 route rather than the Part 7. We've established that there are two processes to apply for housing in some way. The homeless application is what we're focusing on this webinar. And if these paragraphs here refer to the homelessness statutory, the statutory homelessness code of guidance. So 18.5 says the following, and it's talking about homeless applications. So homeless applications can be made to any department of the local authority and expressed in any particular form. They need not be expressed as explicitly seeking assistance under Part 7. So there's no fancy language you've got to use to make a homeless application. As long as the communication seeks accommodation or assistance in obtaining accommodation, so that's the first thing, and includes details that give the housing authority reasons to believe that they might be homeless or threatened with homelessness. That's the second thing. This will constitute a homeless application. So you only have to satisfy those two criteria. Ask for help with housing in some way and give the local authority reasons to believe that you might be homeless or you might be threatened with homelessness, so you might be about to become homeless. That's the application. That's when it's triggered. It's not in 3 weeks' time when the housing officer gets round to meeting you or speaking to you on the phone or something. It can happen any time of day or night. It's immediate, non-deferrable. That's the way this duty works. There's loads of kind of cool case law and this sort of stuff, but this is one of many that just kind of makes the point quite nicely. So Tower Hamlets, XP Furdus Begum. Whether he applies to the right or wrong department or authority should not matter. It should not tell that person to apply elsewhere. The game of pass the parcel has no place in this field. So if we actually kind of just note something else from the homeless application kind of trigger point, it doesn't mention local connection, doesn't mention intentional homelessness, doesn't mention priority need yet either. These are all things that happen later. You can apply to any local authority in the country. Now, it's not always worth your while doing so, but you always can do it. And the idea is that it shouldn't matter which authority you apply to. There's this kind of idea of no wrong door. You should get help, basically robust help from the local authority you approach. And it's not just a case of telling you to return to your local area. That would be gatekeeping. That would be unlawful. Just a bit you guys might be interested in terms of homeless applications. One of the kind of factors you have to take into account sometimes is that to make a homeless application, you need capacity, mental capacity to make that homeless application. However, there's a tendency from housing officers I've seen over the years who they will see some kind of mental health condition like some kind of psychotic condition like schizophrenia or something, and they will immediately jump to the conclusion that that person doesn't have mental capacity to make the homeless application. Now that's wrong for the reasons you all know it's wrong. First of all, you assume someone has capacity, and then you would have to go through the kind of formal mental capacity assessment process to establish whether or not they do have capacity. And this case from Mendip, from an LGO case from a few years ago, basically made the point that housing officers should get training to to be able to carry out their own mental capacity assessments and shouldn't rely on social workers' assessments, although they can obviously they're helpful, which many housing officers have never had training about any of this before. And essentially, again, just kind of, I'm not going to kind of read it all out word for word, but it just kind of sets the point, sets the way that this should work in practice. So in effect, if you have a housing officer who is saying, we're not going to accept a homeless application from this person because they lack capacity, your first thing to do on the route of challenging that, if you don't agree with that, is that you say, well, let's see the mental capacity assessment then, please. And let's see what you did to support that person to make the decision. If they weren't able to have capacity initially, what else did you do to make, to support them to be able to do that? That would it would work in the same way that I'm sure you guys see frequently in your work. It's the same kind of principle. It's the Mental Capacity Act we're talking about here. It's not something else. I mentioned gatekeeping already. We talked about homeless applications and the fact that it's a low threshold, the fact there's no wrong door. The reason we have gatekeeping is partly because local authorities haven't chosen to use their resources very wisely over the years, and central government has got away with not building enough houses and all that sort of stuff. But I'd say, the real reason we have gatekeeping is that it's just rife and no one challenges it. Now, in Bedford, I'm not going to give you I can give you some very brief stats. In Bedford, we have seen a huge increase in the law-abiding kind of work of Bedford Borough Council. One indicator of that is the fact that Bedford Borough Council's, the number of single people in temporary accommodation has gone up by something like, I'm just doing the maths in my head, about 20 or 30 times more than the national increase, or than the average increase. And that has been publicly, kind of acknowledged in the Housing Committee in Bedford to be because we were challenging decisions regularly. And it's that consistency that matters. You can basically make a housing team start following the law, or kind of follow the law, more closely by holding them to account to these laws. Because as we saw in that Imam v. Croydon case, it's legally binding if you're willing to actually believe that it is. So this is a report the LGO did. If you want to, again, if you want to know more about this, I'll put the link to this in the chat as well. So again, have a little look. But it's just very typical gatekeeping practices. You've got no local connection, you're intentionally homeless, whatever it might be. Those things are gatekeeping. That's not lawful at that stage, because anyone can make those initial applications, or that initial stage in the application. Again, it's a term you can search for in that database, and I'll have another go at putting them on in a minute. I can't remember how many gatekeeping cases there are. There's a lot. This is one example. So in this case, the council was at fault as it failed to offer interim accommodation when Miss X first made her homeless application. Blah blah blah. So you can kind of see this happens a lot. There are also some cases on the database where you've got the interaction between housing and social services where it's gone wrong. Usually it's because the two departments didn't, kind of work closely together, and basically expected the other department to fix everything. But the LGSCO's expectation is that social services and housing work very closely on cases involving homeless person with care and support needs. That's the initial duty to accept a homeless application. So you ask for help with housing, you give the council reasons to believe that you might be homeless or you might be threatened with homelessness. It very quickly we get to the interim accommodation duty, which is one of the best things about the Part 7 process. And effectively, the interim accommodation duty kicks in if there is reason to believe that the individual, the applicant, may be homeless, eligible for assistance, and have a priority need. Now, we're going to talk more about eligibility and priority need in a minute, but it's a low threshold. The word here is may. They may be homeless, may be eligible, may have a priority need. You do not need definitive proof before you get to this point. If someone says they're pregnant, then there's reason to believe they might be in priority need. You don't need to see the doctor's midwife letter or anything like that, or take a pregnancy test. You've said you're pregnant. Unless you are known to be a convicted benefit fraudster, the council's default position is to believe you. So you then get accommodated immediately, and then it's then the council's job to make inquiries of the midwife to work out if you are actually pregnant. That's just one example of many. A case called Edwards in Birmingham, which is a good one for this sort of thing, made the point that the Section 108 threshold it's talking about here is low, and indeed clearly low by design, in view of the vulnerable individuals it is intended to protect. So this is, I need to get the quote from this. It says elsewhere that housing law is there to house people. That's the point of it being there. It's not there to not house people. So essentially, it's I mean, there's various other bits and pieces in case law which have made the point that, if someone literally just turned up at a housing team and just said, I'm homeless and I'm pregnant and I'm a British national, for the sake of argument, that council then has an immediate duty to house that person in suitable interim accommodation. So there's a question there. So if someone is in hospital and does not want to return to a specific area where their property is due to mental health, trauma, etc., would case law apply to support a move? So potentially yes, as Will's just put there. First of all, they could approach a different local authority. Effectively, the first barrier you would have to cross there is the fact that you'd have to show that they might be homeless. And so effectively, you would have to make an argument to say this person has a trauma-related condition, let's say PTSD, which is related to the location of their accommodation. Therefore, we think they're homeless. We therefore think it's not reasonable for them to continue to occupy. Not unusual to have cases where you've got domestic abuse, serious domestic abuse happening, where the association of living in that property is going to be triggering for that individual, and you can make that kind of argument for that. But that's not the only place you can make the argument. And again, just to make the point here that Section 108, so that these three things here, might be homeless, might be eligible, might have a priority need, again, do not mention local connection and do not mention intentional homelessness. So again, if councils followed the law, you could turn up at any council. If you meet these three criteria, they have an immediate duty to house you in safe accommodation, and then they carry out inquiries to work out what what the long-term duties are going to be to you. So, duty to refer. This is something which, it's annoying basically. Many of you will be subject to the duty to refer. It applies to statutory social workers, effectively, or social workers that work for statutory organisations, should I say. So like councils, obviously, but not just councils. It could be hospitals, that kind of thing as well. A lot of social workers I have trained basically have given up with the duty to refer because they've done it X number of times. Nothing ever happens. and so they basically just give up. And that is a shame because the reason nothing's happened is that the duty to refer, as we see in 18.7 of the Homelessness Code of Guidance, the duty to refer will not in itself constitute an application, a homeless application. That is because the duty to refer gives the local authority reasons to believe they might be homeless, but bizarrely, it doesn't ask for help with housing. So it doesn't trigger those two conditions of the homeless application. And so effectively, if you do a duty to refer form, the housing officer gets the form, gets the email or whatever it is. They try to ring the patient one time, put the phone down. Well, we tried. That's the end of it. Whereas if you make a homeless application, if you send a communication of some kind, which would be an email if you're sensible, and you give you satisfy those two conditions, the local authority is stuck with that application until 56 days have passed of no contact, basically. So if you trigger the application rather than the duty doing the duty to refer, you've already massively increased the chance of your patient or your client or whatever getting help. Now, I probably should say at this point that if you work for a statutory organisation and you are subject to the duty to refer, then you do need to do that form, but then follow it up with an email which basically says, Joe Bloggs has given me consent to make an application on their behalf. They're being discharged from hospital. They've got X, Y, and Z diagnoses. We're worried about them if they were homeless, whatever it might be. That is going to be that's the best way to do it. Basically, we did a webinar back in June, which is on the YouTube channel, which was like how to trigger a homeless application. I think the title was, and we basically go through the information you need to do to make your own template homeless application, because it's difficult to make a universal template letter for that sort of thing because everyone's remit is different, but it's not that difficult to make your own email. And I would say, and again, I'm probably, I don't want to be too annoying about this. I would say that if you work in a hospital discharge team, this has to be part of your job. Getting your head around housing law has to be part of your job because it is so effective at getting people safely discharged and out of the ward and stopping bed blocking. A couple of questions here we're just going to deal with as we go. So if someone gets to Section 21, is it legal for the local authority to say you're making yourself intentionally homeless before the bailiffs come? Absolutely not. That is definitely not legal. You can get compensation for when they say that. Again, if you go to the LGO, in fact, I'm going to get the link to the website instead actually in a minute because Will, could you possibly just search for Homelessness Best Practice LGSEO database and stick the link into the chat because that does work. But if you search for the term bailiff on that database, again, there's examples where that's what people have been told, and yeah, you get compensation for it basically. So yeah, that's not legal. Another question here: how to approach challenging decisions where someone has been found to be intentionally homeless? Is there a time frame to make this challenge? Good question. Yes, there is, and whereas I would say that most homelessness law is quite forgiving, challenging intentional decisions is not forgiving. You essentially have 21 days from the date of receiving the negative decision to challenge it through the Section 202 process. Not that you need to really remember that because it will say it in the letter, but you need to basically put the challenge in. The problem with intentional homeless decisions, and we'll come back to this in a minute, is that if you don't challenge it, even if the council's wrong, even if the housing team are wrong, it then becomes incredibly difficult to then go back and challenge it in future. It can be done, but it's not a problem you want to be having really. So yeah, if you are supporting someone who is receiving an intentional decision, you need to sit down with them and basically get a letter in pronto. It doesn't need to be perfect within the 21 days. You can literally just write an email saying I wish to challenge the decision, and then you can kind of do your homework and put the detail in afterwards. But you do need to request that review of the decision within that 21-day time period. So yeah, but yeah, sorry, we'll just put it in there. Sorry, I'm a little bit behind here. So the YouTube channel is called Homelessness Best Practice. You should be able to find it reasonably easily. So yeah, good question there about suitability of accommodation. And again, I'm going to defer to the LGO database. So what if the only accommodation they can offer is a hotel room, and this does not meet their physical needs, mobility problems? So that would be unlawful because any accommodation that the council offer has to be suitable. Let me rephrase that to be technically right. Any accommodation the council offers as part of their legal duties has to be suitable. And so there would need to be a written suitability assessment. It might be called something different, which would basically set out what that person's disabilities might be, what their support needs might be, and how it is that that offer of accommodation meets those needs. If they haven't got the assessment in place, if the assessment doesn't exist, the local authority is probably going to lose it if you were to then then challenge it, because there's a really good case called YRV Lambeth. So the letters YR and then V Lambeth, which you can see a lot kind of how that works in practice. So yeah, thanks, Will. So Will's just put the LGO database in the a link to it in the chat, and we'll figure out the slides shortly. Now, and again, I'm going to go off on a bit of a tangent on that question as well. In Bedford, there was a time when they had no wheelchair accessible temporary accommodation available, and we knew this because we had clients who needed a wheelchair who were being offered unsuitable accommodation. So we didn't only challenge it in the for that individual, but we then took the question to the local public meeting. So the housing committee in Bedford is a public meeting, and we basically said, look, what do you do when someone turns up who needs a wheelchair? And they couldn't give an answer, but then they purchased 7 wheelchair accessible properties so that they would be able to do that, because clearly it's discrimination to kind of have a situation where people who need a wheelchair are disadvantaged systematically because of a council's failure to have suitable accommodation available. So if you think back to that Imam B. Croydon case, that was a very similar case in effect, because the family member had a disability which needed a type of accommodation, and the council's excuse of we don't have anything wasn't a good enough of an excuse. They had to find something. So yeah, duty to refer is not what you think it is. It doesn't work because it doesn't actually trigger a homeless application. You might think, well, why do they make the law like this? The answer is because they're politicians and they just want to look good. They don't actually care if it works or not. There's lots of other examples of that sort of thing happening. This is an example, so case me and Will worked on a little while ago. A single homeless woman, rough sleeper, very vulnerable for various reasons, obviously in priority needs. She was in hospital. She was about to be discharged. She was, yes, as it often happens, the decision to discharge was made kind of at lunchtime, and they were going to discharge her later that day. I got on the phone to the discharge worker and I basically said, you need to make a homeless application, basically, or at least do a duty to refer, at least do that because you have got a legal duty to do it. And she just basically refused to do it. She said, we'd only do that if they have severe care and support needs, which is not legal at all. And lo and behold, they discharged her to the street. So she slept rough that night. Now, fortunately, Will was able to write a letter to the legal team at their council the next day to get it sorted out, and she was then housed. But I then did a freedom of information request to the hospital, basically saying, how many people is this affected? And so we can see the results here. It was the hospital in Taunton. They had identified 208 homeless patients in the first 10 months of 2024, but only made 3 duty to refers. Now, again, this is a problem, but I suspect the reason they weren't they weren't making duty to refers very often was they're not very effective. If that discharge team had got their head around the law and were making homeless applications, I think that would be a very different picture. And you wouldn't have to discharge people to the streets in almost every case. So a question here, is it a good idea to go armed with relevant case law if you need to appeal, or is it a good idea to state relevant case law on an application so they know you mean business from the off? Yeah, I think if you know it, if you're confident with it, then it doesn't do any harm, I don't think. Certainly when I started doing this sort of stuff, I was kind of like, reinventing the wheel, really. I hadn't seen anyone else do it. And I would have very long challenge letters, sort of like 10-page letters, which would kind of quote lots of different LGO cases and bits of case law. These days, I don't do that so much. It's generally much easier just to kind of state your facts. But it's not a bad idea. What I'd say is what really matters about showing you mean business is when they push back on you, you then kind of, you escalate it. Which for me, as someone who's not employed by a statutory organisation, I will literally just send a formal complaint to the chief executive of that council, and that works. That does the trick. I appreciate not everyone can do that, but I'd say unless you're willing to kind of escalate it and kind of and dig your heels in, they will know that you don't mean business. And so when you send another homeless application in 2 weeks later, they'll just say, oh, it's only Joe Blogs. They're not going to actually do anything about it. So we'll just fob them off. So that was a physical health hospital. Not that it makes that much difference, but yeah, the law would be the same for both. Yeah, hospital discharge, other bits and pieces. So again, quoting case law. One of the first things you will have happen when you do this is that they'll come back and say the person needs to come in. That the individual needs to come here in person to make an application, or you can't make an application on someone else's behalf. This case here, RV Chilton DCXP Roberts, just basically says you can do it with a letter, quite frankly. And these were travelling showmen. They were basically elsewhere in the country when the application was triggered. You don't need to be in the area you make an application to. If you're about to be discharged from hospital, legally speaking, you could you could contact 10 different councils just to see which one got back to you first. It's not a great way of working, but it's legal to do that. And as we'll see in a little bit, local connection is also going to play a part here, because you can apply to any council without local connection, but at some point in that process, local connection will become relevant. So again, it gets a bit technical, which we'll come to in a moment. So yeah, emergency duty teams. So bearing in mind, if you work for a unitary local authority, and you're a social worker in the emergency duty team, you have got a poison chalice of a job, because you will have people ringing up, telling you they're homeless, telling you they're pregnant, telling you they're vulnerable for whatever reason. And legally speaking, the duty to accept the application and accommodate under Section 108 would be a low threshold, would be happening a lot. Again, I've trained quite a few people in different emergency duty teams. It's not unusual practice for the housing team to email the emergency duty team a list of individuals to definitely not house, and that is often unlawful. I mean, there will be some times when actually there is no duty to house that person, but it's quite rare. So how you deal with that, I don't really have a good answer for you. I've certainly taken referrals from emergency duty team workers to then go back and challenge their colleagues in housing to get it sorted out. But it's a tricky one to navigate from from a job security point of view. But the law is very clear. You can ring up a council at 3 o'clock in the morning, give the council reasons to believe that you might be homeless, you might be eligible, and you might have a priority need, and there's an immediate duty to provide safe accommodation for that person. Everything I've said until this point, I'm confident in. This is something which I'm not aware of any case law on, but if you put together the different bits and pieces of the Homelessness Code of Guidance, which basically said you can make a homeless application to any department of the local authority and express it in any particular form, in theory, if you have an individual who has, or a safeguard has been raised for them, and in that safeguarding alert, it gives details to say they might be homeless, might be they're being cuckooed. And in the little box which says, what does the individual want to happen? If the individual says, I want X council to help me out with housing, I would say, legally speaking, that's a homeless application there and then. Again, it's kind of like pushing it to its limits, but that's the idea, is that there should be no wrong door. There shouldn't be people who are homeless and are vulnerable who are left out on the streets, essentially. As I say, this slide here, I'm kind of 90% on, so don't march into your housing team and sort of throw this at them, because it might get egg on the face. But it's certainly worth kind of just considering it. If you work in a safeguarding team, you have a situation come in where you've got somebody who might be homeless, you want to be making sure that that person has been given the opportunity to make a homeless application, let's put it like that, as a way to kind of cut through the uncertainty here. Multi-agency settings, again, housing officers have this uncanny ability to not mention the duties they have. So if you're in, it could be child protection meeting, it could be safeguarding meeting, it could be a MARAC, you want to be poking that housing officer who's in that setting, who's being very quiet, and making them say what duty might be owed to that person, because there'll usually be a duty to house at some level. But if you don't prompt them, then they can probably get away with just remaining silent. So you just, again, I've seen it done where you've got a particularly tenacious chair who will put them on the spot and say what duties are owed to this person by the local housing authority. And then they'll make a point of minuting the exact wording that comes back as a way to kind of hold that housing officer to account. So, just kind of prompt your colleagues in housing in those sort of settings to lay out what the options actually are, and be prepared to fact check them and kind of be prepared to challenge, because it's not unusual for housing officers, even when you do prompt them, to say something to actually either withhold bits of information that are really important, or just basically say things which aren't true. So again, there is no one else who's going to hold these guys to account, basically. Right, that's homelessness. Yeah, in a nutshell, that's homelessness and making an application, and the interim duty to accommodate. Now, you might remember the interim duty to accommodate, the Section 108 duty, is where they might be homeless, might be eligible, might have a priority need. So we now need to look at what does eligibility and priority need mean to actually kind of put this all together. Eligibility is essentially something like having recourse to public funds. It's not exactly the same idea, but it's pretty close to it. And under housing law, although there is a duty to provide advice and assistance to everyone, as in anyone can approach a local authority, make an application and get some advice, but the decision might be that they're not eligible. So anyone can do that. There is no actual duty to put a roof over someone's head if they are definitely not eligible. Remember that the threshold is might be homeless, might be eligible, might have a priority need. So if those three criteria might apply, the duty stands. But if the council were then to make inquiries and figure out the person isn't eligible, then that accommodation duty would then end shortly afterwards, a couple of days or whatever afterwards. Yeah, so basically, there is not a lot of good news for people who don't have recourse to public funds under housing law. As there may be some local charities that kind of might be able to help out, but there would still be situations when there are duties owed to that family or that person who is homeless under either the Care Act or the Children Act. So if there are children involved, dependent children involved, then Children Act's going to kick in. I'm not going to pretend to know more than you guys about that, so I won't say much more. And where you've got someone who has care and support needs that warrant respite care or something, then potentially that there would be a duty to help them in that way, in that situation. Plus, you've got ineligible pregnant women who, if I understand it correctly, would come under the Care Act in the sense of, although there's not a duty to house them, there would be a power to house them because of it being kind of like cruel and degrading treatment or whatever. That is not my area. I've only seen that happen once. But in theory, if you've got an ineligible pregnant woman, children's services don't have a duty to them because the child's not born, but the adult services would potentially be able to help out in that way. There would certainly be a power to help. So that's eligibility in headlines. Priority need is not something we've got time to go into great detail today, unfortunately, because it is by far the most complicated bit of housing law that matters, and it matters a lot. If you're not in priority need, you don't even get interim accommodation. So, or if there's no reason to think you might be in priority need, you won't even get interim accommodation, let alone anything else that's good. There are automatic characteristics of priority need. There are 6 of them, but the ones you guys are most interested in will be having dependent children in the household, having pregnant individuals in the household, and also people who are homeless as a result of domestic abuse. Those 3 are all automatically in priority need. You've then got 16 and 17-year-olds who have declined support under the Children Act, as in they've been assessed and they've then declined it. They can then make a homeless application and they'll be in priority needs. And you've got 18 to 20-year-old care leavers who were formerly a relevant child. I'm never confident with that little caveat there. But if you want to see more about that, look at Chapter 8 of the Homelessness Code of Guidance. You can Google it. You've also, the 6th category is people who are homeless as a result of a disaster. Now, in one sense, to kind of use a silly analogy, it wouldn't matter if Bear Grylls, was homeless. If he had a pregnant wife, he would be in priority need, no matter how vulnerable he may or may not be. Equally, if he had dependent children, again, he's going to be in priority need. So there's no kind of like test of vulnerability with those 6 automatic characteristics. You've then got the messiest, most complicated bit when it comes to priority need through vulnerability, which again, have a look on the YouTube channel. There's loads of stuff on there, goes into more detail about that. So in a nutshell, the thing which I see people get wrong most about vulnerability is, well, there's a few things. One is that they'll say, we class this person as a vulnerable adult, therefore they're in priority needs. That is not automatic. So although they probably will be in priority needs, you need to do a lot more than just say they're a vulnerable adult. You need to say what's going to happen to them, or what do you think would happen to them if they became homeless. Equally, there is no diagnosis. You might have stage 4 terminal cancer. That does not automatically mean you're vulnerable. You again need to show that, or the impact of being homeless would have a kind of a noticeable effect on you when compared to a healthy and robust person. What I've just said, there is no way on earth you're going to take all that in. I'm just kind of sort of flagging these things. But just to say that the threshold of vulnerability is not terribly high. I would say that 95%, if not 99% of people with care and support needs will be vulnerable, but you need to make the argument. Case law has shown that people with moderate depression can be in priority needs. So it's not that, as soon as you notice a difference between your client and how they would fare at being homeless versus a hypothetical healthy and robust person, that's kind of all wording from the case law, then they're in priority needs. But this is by far, well, I would argue this is by far the most abused section of the Housing Act by housing officers, because they'll look at someone who has got, literally stage 4 cancer sometimes, probably not quite that perverse, but someone with very significant care and support needs who would obviously be affected by being homeless, who they'll try and maintain as not in priority needs. As I say, the way you would challenge that is take a moment to actually get your head around case law, and then you need to put together an argument which says what you think is going to happen to that person if they became homeless, based on what you know about them in terms of their diagnoses or their the risk of exploitation from others or whatever it might be. So I apologise I can't be more helpful at this point, but there just isn't time today. But there's plenty, as I say, plenty of videos on the YouTube channel about it. There's plenty of other resources you can find as well, which goes into more detail. Something about residency orders, going back to priority need for a moment and having dependent children, where you've got separated parents, generally speaking, a housing department will be at liberty to basically choose which of the parents is the main carer. There are some very kind of tenuous challenges you can make to that, but in effect that's kind of the way it works. And just to say that housing officers are not bound by residency orders imposed by the family courts, basically. So, and actually judges in the family courts have been criticised by judges in the homelessness courts for kind of making those kind of conditions. So it might be that the judge says the children should spend the time equally between the two parents. that is not necessarily enough to then go and win the argument with housing about which of the parents is in priority needs. Right, so there's been some questions in the chat about intentional homelessness. I'm hoping to kind of answer some of them now because certainly some of the slides will cover it. Intentional homelessness is another one which is badly misunderstood, and the first reason why that is that there are three criteria that have to be met to be intentionally homeless. This is 9.7 of the Code of Guidance, if you're wondering. And housing officers generally restrict themselves to this first one, so they'll generally see, yes, did that person lose their settled accommodation because of something they deliberately did or failed to do, in consequence of which they cease to occupy accommodation. And that is where they stop. So they'll look at someone, oh, you committed antisocial behaviour, you committed a crime, went to prison, you didn't pay the rent, you abandoned the property, whatever it might be, and they just stop there. And I'm not saying that there aren't intentionally homeless people out there, but most people don't choose to be homeless, fairly obviously, and most people will be reasonably careful about not losing their home. So for many people who have deliberately done something, they won't be intentionally homeless because these two criteria don't apply, particularly this last one here. So it has to be reasonable to continue to occupy the accommodation. A really obvious example here would be where someone deliberately flees their property because of domestic abuse. Now, that is a deliberate act. They've done something deliberately, which has led to them becoming homeless, but they can't be found intentionally homeless because it wasn't reasonable for them to continue to occupy the accommodation. This is the same term we see earlier in that definition of homelessness. And as we saw with the definition of homelessness, you can be homeless because you can't afford the rent, you have some kind of mobility issue that you can't make use of your property fully, harassment from neighbours, that sort of thing can come into it as well. If it's not reasonable, you can't be found intentionally homeless. Therefore, this just doesn't come into it. Another situation that's not that unusual is where you've got a single, kind of be stereotypical, a single homeless male with drug and alcohol issues who gets evicted from the local supported accommodation. Yes, they may or may not have done something deliberately that led to them to lose their accommodation, but it may be the service charges were so expensive that it wasn't actually reasonable for them to occupy the accommodation. And again, although the two aren't linked, they would not be intentionally homeless. And to then answer the question explicitly, I think from the chat, it goes on to specify what a deliberate act is, 9.17 of the Code of Guidance. Generally, an act or omission should not be considered deliberate where, for example, the act or omission was the result of limited mental capacity or a temporary aberration or aberration caused by mental illness, frailty, or an assessed substance misuse problem. I haven't included it in here, there's a case called Kendall v Westminster where a lady became homeless because she didn't manage her accommodation. She was addicted to crack and heroin at the time. A couple of years later, she then was basically made a fresh homeless application. She was found intentionally homeless, but that was quashed by the judge because the judge said it looked like the accommodation had basically been lost because of essentially her drug addiction, which had impaired her ability to manage the tenancy. Yeah, so it's not that unusual to have someone who has a psychotic episode, trashes the flat in some way, understandably gets evicted from the accommodation by the landlord, but that doesn't make them intentionally homeless because there may well be evidence that they lacked mental capacity at that point in time. So again, hospital discharge teams who are in inpatient psychiatric units probably see this stuff come reasonably often. So again, it's a good bit of news. There are other bits I'm not included here, so we're only looking at C and D, but then we've got D here. The act or omission was made when the applicant was under duress, so this would cover things like cuckooing. So you've got someone who is storing guns and running drugs for a local gang and they go to prison because of it. If it then becomes apparent that they're actually being cuckooed at the time, they can't be found intentionally homeless. Although bear in mind, a lot of people being cuckooed won't be willing to actually say that out loud because they fear that they'll be seen as a grass. So you have to kind of deal with it fairly carefully. Staying on intentional homelessness for a moment, and again, I don't know why social workers don't get this training because it would save you a lot of hassle. If you work in children's services, if a family with children, dependent children, is found to be intentionally homeless, then assuming that the family or the parents have given consent, that family would then be referred to children's services as a family who are homeless. As it says here, actually, where it involves safeguarding, it might be that it's done without their consent. So I would imagine that if you're working in children's services, you're going to have these families referred to you fairly regularly who have been told that they're intentionally homeless. Going back to that question we saw before about how long have you got to challenge it, you've got 21 days. You want to be picking apart that intentional decision straight away to be looking to see if there's anything which basically undermines it. So I mean, I'll give you some examples off the top of my head. One of my most easiest ever compensation claims was for a lady with kids who She went into the local housing team, told them she was being abused, and it was credible. She, turned out to be entirely correct. And the housing officer told her that if she left the property, if she kind of gave up the tenancy, then she'll be found intentionally homeless. Now, that's clearly not correct, but you'll see these kind of perverse intentional decisions being given. So, again, just don't be naive. You need to pick them apart and see if they can be challenged. Because if they can be challenged, you can then, challenge the intentional decision, get it overturned. That family will be in priority need because they got kids, and therefore, to be kind of cynical, it's not your problem again. It's not your problem anymore unless there are safeguarding concerns, kind of anyway. And so yeah, I mean, I can't, social services are not set up to house people, obviously. So you want to be basically batting people away back to housing who are the specialists in procuring housing as much as you legally can. So you definitely want to be picking these intentional decisions apart. There is actually a bit of a process. So although you've only got 21 days from the point of getting the decision, often housing teams will write a draft decision first called a minded to letter. Now, at this stage, they don't have to do that, but they often will. And so it might be that you have even more time to kind of get your argument together before you kind of need to make that challenge. So yeah, so the question is, so if we can prove they had substance misuse issues due to mental health and lack capacity, we could challenge this under the Housing Act, absolutely. So again, just be prepared for the idea that the housing team will say, okay, yeah, well, they didn't have mental capacities, but actually that means they can't make an application at all. So again, you then have to educate them and say, no, mental capacity is fluctuating. It might be that on the 1st of January, they didn't have mental capacity, and on the 1st of February, they did, and that's when they made the application. So just kind of be right. A few of the bits and pieces you want to know about intentional homelessness. First things first is there is no such thing as an intentionally homeless family. There is only such thing as an intentionally homeless person. So if you have two parents and the dad is found to be intentionally homeless, there is nothing stopping the mum making an application on the day that they get evicted from TA and starting the whole process again. Now, it may be the mum's intentionally homeless as well, we don't know yet, but there are certainly situations where that can kind of save the day, and you can kind of get around that problem of missing the 21-day deadline. Same would apply to adult children in the household. So again, I've worked on cases like that before where the adult child has been the one who makes the application. They weren't part of the behaviour that led to them being evicted in the first place, so they're not intentionally homeless, and so you kind of get around it that way. And if you're really desperate, if you get found intentionally homeless by Council A, you can approach Council B and just start the process there again. And remember, the intentional homes decision doesn't stop someone getting accommodated. Now, actually, I've missed out Section 190 of the Housing Act on my slides here. I probably shouldn't have, because Section 190 says if you are in priority need, but you're intentionally homeless, there is still a duty to house you for effectively about 3 or 4 months. There's not a time limit exactly, but it's 3 or 4 months. Suitability of accommodation is the second most complicated bit of housing law. And frustratingly, the Code of Guidance in Chapter 17, which is all about suitability of accommodation, uses very passive language. So the bits I've quoted before, so if we go back to like 18.6, whenever that was, or 18.5, sorry, this is explicit. This is telling you what the law is. There's no wiggle room there. That's the way it works. Whereas in Chapter 17 of the Homelessness Code of Guidance, it kind of will say stuff like councils should consider the importance of pets to applicants, which is kind of good, but it falls short of saying that councils must house applicants with their pets. Interestingly, if you search for the term pets or animals, but search for both of those terms on that database, again, you'll see cases where you've got families or households with pets who the council did need to house them with their pets because of social and emotional issues, basically, kind of the support they gave. It's same kind of idea here. So the Code of Guidance is good, but it's falls short of being kind of like really kind of clear cut when it will say something like, where you're working with someone who has got drug and alcohol issues and they would benefit from being housed in a different area to get away from negative associates, the council should consider housing them in that way, but it falls short of saying they must do. So yeah, although they got a lot of the guidance is kind of basically legally binding because it's just telling councils how to interpret the law. On issues around this kind of stuff, it's a bit more grey, let's say. But these are the kind of things that are relevant to suitability. So location of accommodation and proximity to support network. Now, bearing in mind, if you work in London, you'll probably have seen families been housed in like Durham. So that's not legal, but you have to challenge it. Effectively, if a council can't house you in its own district, it has to try and house you as close as it possibly can do. And no council can legitimately say the closest accommodation is in Durham. It's 200 miles away. That's nonsense. You'd be surprised how many London councils are able to find accommodation in their own district. So is something that you want to challenge basically. Transport links as well, so things like kind of getting to and from school is relevant here. So there's guidance about, it's called like travel to school guidance. It's something that simple, but basically it specifies that primary school age children need to be within 45 minutes door to door of their school, and secondary school age children need to be within 75 minutes. Now, yes, that means councils will try and get you to move area altogether and get you to change schools. But again, you kind of have to piece this sort of argument together. Things like cost of accommodation, pets, already mentioned, proximity to employment, these are all things which are relevant. The reality is that sometimes councils genuinely are struggling to find accommodation in the area. And other times, councils are trying to give you the worst possible offer of accommodation because they hope you're not going to take it up. So, in reality, it's quite difficult to kind of know the difference sometimes. If you search for the term suitable on the database, again, there's loads of examples of unsuitable temporary accommodation, but also unsuitable permanent accommodation, which again, you can see the nuts and the bolts of how this all should work. And again, out of all the things within housing law, unsuitable accommodation is probably the one which results in the biggest compensation payments. So, for example, there's a 6 week limit on families with children being housed in B&Bs, and if you go over that 6 week limit, then you get between £100 and £200 per week you're in that B&B accommodation. So that's very straightforward to make a complaint about, really. We've got 10 minutes to take questions. Just to say, ignore that first bit because I've just copied this from a different thing. But basically, and we don't do this anymore at the moment, actually. So we were doing a weekly live stream, but it's on a hiatus at the moment. But Will has compiled this very helpful list of solicitors. Have you already put that in the chat, Will? If not, I'll put it in again. So that's just basically a list of solicitor firms that take housing cases effectively. I don't think Will's going to like me saying this, but Will works for Morrison Spowett, and they're always worth a try. I'm not saying that he's got loads of capacity, but sometimes they do. There's a Facebook group which basically is just a space to ask anonymised what if questions. It's probably the quickest way to get an answer out of us. Just make sure it's anonymised. And you guys are probably, yeah, in fact, you guys all have come through Eventbrite. Keep an eye out on the Eventbrite page for other free webinars and also upcoming training dates. Very reasonably priced, exceptionally good feedback that we regularly get. Plus, if you're thinking about getting this kind of training in more detail for your team, then just get in touch because, as I say, I do regular training for social work teams around the country as well.